Ladies and gentlemen, thank you for standing by. Welcome to the 3 Must-Have Training Courses for 2013 webinar. If you would like to ask a question during the presentation, please use the chat feature located in the lower left corner of your screen. And as a reminder, this presentation is being recorded Thursday, April 18th, 2013. I would now like to turn the presentation over to Liz Williams. Please go ahead.
Hi everyone, this is Liz Williams with Workplace Answers. I'd like to thank everyone for joining us today for 3 must-have training courses for the 2013 webinar. This presentation is brought to you by Workplace Answers, and your presenter is Lynn Lieber, Esquire. If this is your first time joining us, or if you're a regular, welcome. We're very happy to have you online with us today. Before we get going, I'd like to tell you a little bit about us. Workplace Answers offers the most compelling and interactive online compliance training solution in the industry. We bring cutting-edge courseware and the latest training applications together with a dedicated professional services team to transform the way you educate your workforce. Today's presenter, Lynn Lieber, has been practicing employment law exclusively on the management side for nearly 25 years. She has conducted face-to-face employment law training sessions for hundreds of entities. She has also testified as an expert witness in unlawful harassment matters and frequently conducts remedial training for supervisors or executives who have been accused of harassment or discrimination. Now there's a few housekeeping items before we get started as everyone's filing in here. We'd like to let you know we're offering a limited time promotion on our courses as part of this webinar. Starting now through the 31st of May, we are taking an additional 10% off all multiple course packages. This includes the Core Compliance Bundle, which Lynn is covering today. So stay tuned for how to take advantage of this promotion later in the webinar. Now if you look to the left of your screen, the bottom left of your screen, there's a chat feature, and you may submit questions to the speaker at any time today by typing them in this section. Questions will be addressed at the end. As time allows, we'll do a little Q&A. And as a reminder, today's call is being recorded. Unfortunately, we do not provide the actual PowerPoint slides, but all registrants and attendees will receive an email which will contain a link to view the recording and a download link for a document that has some key takeaways of this webinar. You should receive a call from one of our reps after the webinar to ensure that you receive the link to the recording, to get your thoughts on the webinar, and to see if we may be able to assist with any of the issues discussed in today's webinar. We would really appreciate it if you would take a few minutes to chat with our sales consultants when they give you a call. Now we'll also be conducting a few polling questions during the presentation, so all you have to do is just click the radio buttons to select your answer. On most of them, you'll get to see everyone's responses. If you're on Twitter, we invite all of you to use the hashtag HRCompliance, so hashtag HRCompliance, both during the presentation and to extend the discussion after Lynn is finished, so we can kind of keep that going. So without further ado, I would like to now turn the call over to your presenter. So please go ahead, Lynn.
Thank you so much for the introduction, Liz. That's fantastic. I am very pleased to be with you all today. This is a subject that I have immense passion for because I believe that training is such an essential component of every HR person's job and every supervisor's job, and I have seen it for 25 years in my practice either allow employers to establish an affirmative defense and avoid liability or get hit with punitive damages. So I think what we're talking about today is a very, very critical issue for HR, especially in this year, 2013. So I wanted to begin on the next slide with our training essentials. So we believe that these are really the top 3 courses that every employer needs to train in. Many employers have trained in unlawful harassment for years. They now need to do different unlawful harassment training. They need to include the new protected categories, and they need to include the new law on retaliation. And it is critical, which I will discuss later for legal reasons, that not only all employees be trained in unlawful harassment, which covers not just sexual harassment, but race, discrimination, religion, age, all the protected categories, but that supervisors need to know their obligations under the law, how to receive a complaint, how to deal with retaliation. There are 3 Supreme Court cases on retaliation that have completely changed the landscape. Secondly, we're going to talk about a standalone discrimination EEO training for your supervisors that again includes retaliation. Remember, discrimination can happen during hiring, during employment, during promotions, during demotions, during literally any type of term or condition of employment. And I think finally, one thing I'd like you to take away as one of the biggest learning items here is that we need to train supervisors in wage and hour law. And this has become essential, and this is actually your greatest employment liability, which we'll discuss. Before we leave this slide, I want to tell you some things that I often hear from employers in my practice. And those are questions like, why do I need to train? I have a policy in my handbook and all employees accept it. Isn't that enough? Second question, why do I need to train all employees? Why can't I just train my supervisors? What I'm going to do in this webinar is tell you the law of why you need to train. And there are federal training requirements. And the other thing I want to mention before we leave this slide is that training is only as good as your tracking system. Because what you'll need to do is prove to a jury that your employees and supervisors actually completed a course. It's no longer enough to say that we have a sign-in sheet, that we showed that someone got an email that registered them for training. You need to actually show that that person completed the training, what day they completed the training, and that they have accepted your policy. And I've had many cases I've defended where the employer could not show that a policy was accepted because either the person decided not to sign it when they were passing them in a classroom setting. Maybe the person signed in for the training session and sat down but then left. And not surprisingly, these are going to be your employees that engage in harassment and discrimination and are going to be your biggest sources of liability. So let's move on to our first polling question. Let's set a baseline, and I like to do this because it's also best practices for all of you to see what does your organization currently conduct training in. And you have 5 choices there. So please, for all of our participants, answer your question honestly. It's anonymous. No one's going to tell or find out. And once we have many people. We have almost 1,800 people on the line, so this should be a good sampling. And as soon as we hit critical mass, we will move to the results. Okay, I think we're probably ready to see our results. Liz, do you want to hit skip to results? Can everyone still hear me?
Yes, I can hear you.
Okay, we need to we need to skip to the results of this. April, can you help us out? There we go. Did we have a results page or? Okay, well I can tell you what, here we go, fantastic, I'm sorry. This is very telling. So obviously most employers believe that they need to conduct unlawful harassment training. That's been embedded in HR's mind. So as we see out of this group, nearly 60%, which is fantastic, do unlawful harassment training. I worry about the 40% that doesn't. Interestingly, almost 43% engage in discrimination training. And again, I urge that to be a standalone course. One of the amazing things about this is that only 6.3% of you train in wage and hour law. And as we'll see in later slides, this is your largest employment liability because your managers and supervisors simply don't know the law. And I'm sorry to say that over 20% do not do training. So this really, I think this webinar will be helpful to you in seeing and also pushing up to your C-level, the officials of your organization, the higher-ups in your educational institution, why you need to do this training. So let's go on, speaking of that, to HR's uphill training battle. These are the questions that I get all the time from the C-level, from officials, from government entity, higher-ups. Show me the law that says we need to conduct training. Well, what I'm going to do is educate you on what the law is, and after all, you are going to be the one on the witness stand being cross-examined as to why your organization did not conduct this simple training. And there are numerous cases that show that employers that do training can assert an affirmative defense, and actually employers that do not do training are subject to punitive damages as a form of negligence as an employer. Many higher-ups in organizations believe that training is a good idea, but as we know as HR people, that they see it as discretionary, non-essential. It's something that can be cut from the budget. It's sort of one of HR's do-good things. And that is absolutely not correct. Training diverts organizational time and resources. We're going to tell you ways and show you amazing statistics at what great quote-unquote insurance training provides. And the training can equal 1% of the budget of what a lawsuit would cost you. Many employers have told me that we don't want to do training because we don't want to give our employees all these ideas of how to sue us. Well, what we need to do, and what Workplace Answers does, is train in a very pro-employer manner. What employees need to know is not only what is harassment, but more importantly, what is not harassment. Employees, as HR people know, and many of you on the phone are going to understand this, how many employees have told you, I'm being quote-unquote harassed, or I'm experiencing a quote-unquote hostile work environment? When I do trainings and ask employees if they feel that way, 95% of people raise their hands that they're being harassed at work. So it is critical to tell people what is not unlawful harassment, and I have to tell you that's 95% of what happens in the workplace. all employers engaged in what employees think is harassment, all of us would be in court every single day, all day, because the law does not provide that your supervisor isn't rude to you, doesn't treat you differently than other employees, many different things. So training needs to be pro-employer and proactive. And then finally, senior executives don't need or have time to do training. I know many of you suffer with this issue, and coincidentally, senior executives are more often the ones that need this training because they are very high level. These cases go public. Senior executives are held to a very, very high standard as role models under the law. And so training needs to include everyone from the C-level down, and even including the board of directors of your organization, the board of regents. It needs to really come from top down. So let's move on to the law, as I've told you. This is something I think you can, all these current federal training requirements you can share with your C-level. For employees, it's very critical that they understand what their rights are under the law, but also what their responsibilities are. Employees can be personally liable for engaging in acts of unlawful harassment. They need to know what steps to take if they feel harassed. So this makes policy acceptance tracking essential, because that's what you're going to show to a jury as to demonstrate that you established an affirmative defense, because you could show that your employees took the course, how long they took in the course, the date they took the course, and this training needs to be for all employees, as I'll show you on the next slide. Managers need to understand how to enforce these policies. Again, we need to show that they have actually taken the training, and they need specialized training that is just for supervisors. So let's go to the framework for compliance training. There is a legal framework that has been set in the law for many years. It begins with the EEOC guidelines on unlawful harassment and discrimination. These are 1999 guidelines that still hold. You can find them on eeoc.gov. And these guidelines state the employer should provide training to all employees. This has been bolstered by cases you might have heard of, the Farragut-Ellerth defense, as we call it. These are 1999 cases, and we saw this as manna from heaven for employers when I was practicing law, when these cases came out. Because literally before this time, employers did not have a defense. Someone could sue them 6 months after they were terminated or left employment for harassment, and the employer really had no defense. So what the court says, in these joint decisions says, is that employers need to quote unquote exercise reasonable care. Well, what does that mean? It's very simply stated. It means you have an updated policy and you distribute the policy. It means that you do training for all your employees and all your supervisors, and it means that you enforce your policy. And what does enforcing your policy consist of? It consists of training your supervisors so they know what is right or wrong, how to stop employees from engaging in inappropriate activity. That's what courts want to see, because if you don't enforce it, that's where you get into punitive damages, because you were a negligent employer. What juries hate most of all is that an employee was subject to a continuing discrimination or harassment situation because the employer did nothing about it. And then finally we have Kolstad, which is a 1999 case. This case says that all managers must be trained in Title VII principles. This is discrimination, and employers need to show good faith efforts. Again, what does that mean? It means training. And that means that employers can limit their punitive damages. To me, these guidelines and these cases are sort of a weather forecast that calls for rain. And this is like an employer saying, we're not going to have an umbrella, we're just going to get rained on. It's very easy to have an umbrella, and it's very easy to do compliance training. So let's move on to our second polling question. What could you show an investigator or lawyer to prove your good faith efforts for a legal workplace? Your choices are a paper sign-in sheet of attendees, email confirmation of enrollment, signature on a policy, web-based courses, or I'm not sure. Okay, when we hit critical mass, let's show our results. Click the button that says Move to Results. So do we have our results? Here we go. Okay. Many employers believe that a paper sign-in sheet of attendees is enough. As I've said, I've worked with many employers, and you would be surprised that 2 years later how many HR people cannot find the sign-in sheet. Obviously, an email confirmation of enrollment is nothing. An employer's signature on a policy, courts say that is not enough. That is not going to show that you have engaged in good faith efforts. What they want to know, and the Kolstad case demonstrates it, is that you have done training. Web-based course certification is actually the best, and I will show you later why that is. So we're going to move ahead with training versus not training. What does training do? Well, as we said, it meets the reasonable care and good faith efforts. It also promotes a professional work environment. It shows employees you care about them, their work environment, and helps with retention. As we said, it does more than check the box training. It shows investigators you are a good employer and that you should not be assessed punitive damages. And not training, no defense, unprofessional activities in the workplace are going to happen. And one of the huge issues in our Internet stage is reputational damage, poor image of an irresponsible employer that goes viral. Let's move quickly on to why training is so important. You as employers are literally being targeted from all angles, and I love the way this slide is laid out because it is so true. You have employee-friendly laws. You have employees that have more access to the Internet than ever. There are websites, I talked to one of them yesterday, where employees can sign into a website for free and insert a complaint, and they get lawyers responding to them within minutes. So there is more information out there than there's ever been. Supervisors just aren't trained. They don't know the law. If a plaintiff perceives unfair treatment, they go to a lawyer, and let me tell you, the employer will come through and say, I have 5 protected categories you belong in. You're female, you're over 40 years old, you're Hispanic, your child has a disability. So they walk in thinking that maybe I've been treated unfairly. They walk out with a lawsuit. We'll talk about increased administrative enforcement, the DOL, the EEOC. They're all working together now. As we all know, there are many heightened ethical requirements, scrutiny, vehement public opinion against it, and then again, as we said, reputational damage, because all this becomes viral in the Internet and it never goes away. So let's move on to unlawful harassment. What is really required is annual training for all employees and supervisors. Employees need to be trained when they come on board. Supervisors need to be trained when they get promoted. As we said, no training equals punitive damages. You are a negligent employer if you show that you could have prevented harassment from happening and you did not do so. And there is personal liability. So let's move on to some statistics. These are fascinating charge statistics from last year. As you see in the first box, 101,000 charges filed. Not surprisingly, retaliation leads the way. Do we do most of our training in retaliation? No. That's what employers need to focus on. Race comes next, which makes discrimination training essential. And as you see, sex discrimination, which includes harassment and pregnancy, it comes third. And that's where we spend most of our budget. $365 million is the EEOC's largest recovery ever through a private sector administrative enforcement. And $44 million was recovered by the EEOC resolving lawsuits last year. Let me tell you, that's resolving lawsuits. Those are not jury verdicts. Those are not private employment actions. That's just the EEOC's settlement process. So multiply that by probably 100 times, and then you get real statistics. What does your harassment training need to cover? Well, it needs to tell people who's protected: applicants, current employees, even former employees are protected. You need to have up-to-date protected categories. The Genetic Information Non-Discrimination Act. Weight is a protected classification as morbid obesity. There are magic words about definitions regarding unlawful harassment. Employees need to know what they can and can't say in social media and on the Internet. We talked about what is not unlawful harassment. They need to know what is confidential on a need-to-know basis. What does that mean? Who are third parties that employees could harass and that could harass employees? And then huge, no retaliation. We know by the organization, by supervisors, but what we see an epidemic of is coworker retaliation, ostracizing someone. That is all illegal behavior. And then most importantly, how to report. Very clear ways to report and alternatives. So what do managers need to know in their training? Well, what is a complaint of harassment or rule violation or wage violation? This is not intuitive. It can be a simple question like, you know, Joe stares at me kind of strangely, or I don't think this person likes me. Supervisors need to know how to receive a complaint. They need to know that they need to sit down, take the complaint, put the harassment policy in front of the person, and tell them there's no retaliation, there's confidentiality. And in the orange box, what to say to the employee, but more importantly, what not to say. Don't say, yes, Susie's done this before, or I'm going to make sure we take care of this. That's all imputed to the organization. They need to know what will happen next. No guarantees. I'm not going to tell you that the supervisor is going to be moved out of their position or transferred, or something will be guaranteed. They need to know that retaliation laws apply to third parties. That's, again, not something that supervisors know. They need to know exactly what behavior can constitute retaliation on their behalf, and that the employee will not be retaliated against and what that means. And managers need to know they need to police coworkers from harassing people and ostracizing them. Okay, let's go through a we'll do this quickly. These are several slides from Workplace Answers, Unlawful Harassment Prevention for Supervisors program. Let's just go on to the next one. This is the Supervisor Supplement. And this one deals with a very important fact that you need to investigate and take a complaint retroactively. So even if the person has left the organization who's the harasser and the employee says there's no harassment going on, you as the supervisor need to bring that to HR. This is, again, something supervisors do not know about. Okay, let's quickly move on to discrimination and EEO. We're seeing very increased enforcement. We have new protected classifications that need to be included in your discrimination training and your discrimination policies. Weight discrimination. Morbid obesity can be a disability. Literally everything is a disability under the law now. And how do you accommodate that as a supervisor? If you are interviewing a morbidly obese person, what do you say to them? What do you not say to them? What do you say to an employee that shows up for an interview who's 7 months pregnant? That's very critical. Gender identity is now federal law. This is someone's appearance, expression, their expression of their gender, whether they dress in male clothing, typically male clothing if they're a woman. You can't discriminate against someone based on that. And that affects dress codes. It affects grooming standards. It affects many things supervisors have to deal with every day. So what do you need to train in? We'll go through this very quickly. Obviously, Title VII are the protected categories. What else do you need to train in? Age discrimination. The highest single plaintiff verdict there is age discrimination. Why? Because we can all relate to age discrimination. We all either are over 40 or want to be over 40 and still employed or know someone who's been discriminated against. The Americans with Disabilities Act and its amendments. Again, everyone is disabled, and employers and supervisors need to know what to do to accommodate disabilities. The Pregnancy Discrimination Act, the Equal Pay Act, Family and Medical Leave. I didn't include it on this slide, but USERRA, which is returning veterans. We have a huge amount of returning veterans to the workplace. And then, of course, preventing discrimination in your workplace and what are terms and conditions of employment. So retaliation, as we said, is a huge issue. There is now a zone of interest, and an employee is punished for invoking rights under Title VII. That enables suit by any employee with an interest. And this zone of interest is yet to be defined. It can be a fiancé, a spouse, a close work friend. Employers and supervisors need to know what this is so they don't retaliate. And third-party retaliation, that's where you need to look at all employment decisions and investigate all claims. Again, these can be vendors, suppliers, the FedEx person. It can be anyone that your employee comes in contact with while doing their job, at a trade show, at a company picnic, anything. Okay, I'm going to show you a couple slides from our Workplace Answers discrimination course. This is one about an employee wearing a hijab, and this one deals with safety. Many employers believe that, well, safety is a valid reason. I can't employ someone who is wearing traditional headdress or insists on wearing a skirt because of their religious beliefs. There are ways to accommodate this, and we need to do that. Okay, so let's move on to another Workplace Answers slide from our discrimination course. This is where supervisors need to know they need to work with HR at every step. These are all the ways they can retaliate against someone. Even if it's taking away someone's duties to be nice to them, to treat them favorably, that can be discrimination. Okay, our third polling question. Have you or a colleague had a lawsuit, a near miss, or nothing to worry about?
All right, and I'm watching these come in, Lynn, and it looks like we're getting a lot of responses. I think it'll be interesting to see. I imagine most people have had something.
Well, there are lots of near misses, I can tell you that.
There should be a lot of near misses, I imagine. They're still coming in, quite a few people, and I think we're going to close the poll out now.
Great. Wow, 40% a lawsuit. And you know, these aren't lawsuits that necessarily go to trial. These are lawsuits that settle for huge amounts of money in many cases. And if you have insurance coverage, the insurance company decides whether you settle a case or not. So you might not want to settle a lawsuit. You might want to take it further. And I would say for those quarter of people that say they have nothing to worry about, I think by the end of this webinar, that number might be a little lower. So let's move on to wage and hour law, which is your greatest employment risk. There are penalties for wage and hour violations. There are liquidated damages for willful violations of the law. And this gives you a very graphic representation of where your liability lies. We always train in sexual harassment, $50 million. Look at wage and hour, $450 million. Training can save an employer millions of dollars, and your return on investment is real. Federal court filings in wage and hour are up 500% in the past decade. And I have to tell you, wage and hour, especially class actions, are plaintiffs' attorneys' idea of heaven. And one interesting part is they can recruit people through social media now. It's very easy to find people. So let's talk about wage and hour litigation issues. We're going to talk about the DOL. They are back in the enforcement business big time. The DOL has just hired 250 new investigators. These are people that go out and do audits of your organization to see if you're in compliance. The EEOC has 170 new investigators. And I can tell you the EEOC, the Department of Labor, and the IRS, which deal with independent contractor and employee issues, are all working in concert. And they are referring these cases directly to attorneys, which is scary. Okay, let's look at our litigation issues. These are big issues that need to be covered in supervisor training. What is an independent contractor versus employee? These are very, very complex issues. It's very easy to get a class action where you have a bunch of independent contractors saying, I was misclassified, I'm really an employee. You're going to get hit with taxes, with workers' comp past payments. You're going to get hit with SDI. California has a worker misclassification law. The DOL and the Wage and Hour Division have worker misclassification initiatives. And then our big issue is overtime. Who is exempt and non-exempt? A gigantic issue. And in California, we have new law on meal and rest periods. If you're in California, you need to train your supervisors in this because the law is doing great. I'm sorry, the law is doing, the law is just changing in incredible ways. Okay, this is shocking, and I know it from personal experience. 80% of DOL investigations for wage and hour claims find violations. In my practice, I do what are called wage and hour audits, and I can tell you that my number would be higher than 80% because these laws are too complex, there are too many issues, and you have managers who are doing it all differently because they simply don't know. And many organizations say, well, payroll takes care of that, or the accounting department takes care of that. That is not true. They might issue paychecks, but they do not determine who is eligible for overtime. They don't determine who's an independent contractor or employee. Again, these agencies are working in concert. So the median verdict in discrimination-related claims, $325,000. That's median. Average cost of a harassment award, over $500,000. So let's look at some wage and hour training requirements that need to be covered in your course. The federal requirements, per industry, per classification, very important, different for every industry. Timekeeping requirements. Supervisors need to know this. They need to know what your lunch and break requirements are. Overtime issues and exemptions. And then my personal favorites that supervisors simply don't understand, and I have to tell you, attorneys don't understand these rules because they're so complex. Travel time, on-call time, reporting time. Ugh, these are horrible. What is retaliation under the wage and hour laws? What are your wage and hour record-keeping requirements? What do supervisors need to personally do? And how do supervisors report potential or actual violations? This is not something supervisors do alone. They don't go rogue on this and say, it's my department, I'm in charge of it. This needs to be brought to HR's attention immediately. Okay, let's look at a couple slides from Workplace Answers Wage and Hour course. This one is for New York supervisors. This talks about coverage under the FLSA and demonstrates that supervisors need to understand how to properly classify employees. And Workplace Answers has wage and hour courses not only on federal law, but New York law, California law, and other laws. So again, very, very important. Next, we're going to talk about practical points. All Workplace Answers courses conclude sections with very easy takeaways. Supervisors can print these out. And one great thing is that Workplace Answers courses, employees and supervisors can return to. A supervisor might take this course and not have any issues at the moment, but when they have one, they can go back and look at this. And they can use it as an ongoing learning reference and tool. Okay, polling question number 4. How does your organization currently conduct training? This will be interesting. How's it going, Lee? I'm sorry, Liz.
Hi, all right, we've got the results coming in, still coming in actually. And I think we're going to close it off right there for you, Lynn.
Great. Combination of online and in person, that's good. That's great. Still a quarter of people do in-person classroom style. I have been an in-person trainer for 25 years. And I can tell you there are very huge downsides to in-person training. It can actually create liability. There's a case called Stender versus Lucky Stores where an attorney went in to do harassment training and actually brought up stereotypes of various people, and the employer was sued, and the plaintiffs used that training session as part of their evidence showing the employer discriminated. It's also a case where you don't really have record of the training content. A supervisor can, a trainer can give you their PowerPoint. It doesn't capture what was really said in that training session or what the employees were presented with, the questions they asked. Plus, it's a place to air grievances. I've had in an open training an employee say to me, based on what you've said so far, isn't it inappropriate for my supervisor to call me by the N-word? Because he does that and I tell him to stop. And I almost fell over. Now, the issue with that is you now have 25 witnesses to that statement being made. And a lot of times they use these sessions just to gripe about their supervisors, and I think it's demoralizing, and many people don't want to say their issues or ask questions. So online is fantastic for that. As we said, there's huge administrative oversight. Training is no longer just an affirmative defense or a prevention strategy. Now, especially with wage and hour law, there are direct penalties for not training today and punitive damages for not training today. And let me assure you, if you are investigated and you cannot show a thorough, complete training program, you will be fined as a negligent employer.
Hi, Lynn. I just wanted to give us a quick time check. We've got about 10 minutes to go, and I'd like to save time at the end here for a quick Q&A with everybody, as well as find out their interest levels. So if we could just move on through these.
Fantastic. Okay, let's go into using your training dollars carefully. As we said, training is more closely scrutinized than ever from a legal standpoint. Your training needs to be up to date. That is why outsourcing is very helpful. It's practically impossible for HR to keep up on, let's say, wage and hour laws and the new protected classifications, the new retaliation laws. So you need training that can be deployed to your entire workforce, the same training. That's another downside of in-person. Every session is separate. And you need to show that training really educates and changes employee behavior. Proving ROI, and we've discussed that poor training can increase liability. Okay. Why outsourcing is smarter and safer. You can go back to look at this slide if you like. You know, the laws have evolved. Courses, web-based courses, workplace answers courses are 100% effective in defending claims. They're interactive. They're consistent. It's very important to be consistent in training because you can actually be accused of discrimination for disparate impact by not training all employees. Let's say you train your supervisors but not your employees. Your employees might likely fall into the protected categories more than your supervisors. So they could say, I wasn't given training opportunities like other people were. Specialized courses mitigates your risk. Online training is far cheaper and more effective than classroom style. Affirmative defense, engaging, trackable through the Slate LMS system, and insurance, as we said, is not a prevention strategy. Okay. I love this slide because I think it really shows just how simple and cost-effective this is. The cost of prevention by training is less than 2% of the cost of litigation. So even at a basic level, taking one course in harassment is going to be a minimal cost. It's going to be 10% of what your employer would pay if they got sued. It's just an amazing return on investment. Workplace Answers has over 45 courses and specialized courses in all these areas. They have 13 years of experience as legal experts. So let's look at the Slate Learning Management System. This is HR's very powerful learning management system. It's very easy. It shows you it gives you 24/7 access to learner data. We can show you a little more detail on it on the next slide. It shows you what course the employee was registered in, how much they completed, the time they spent in the course, the date they accepted the policy, and the date they completed it. This is what a jury wants to see. Okay.
Hi, Lynn.
Liz,
I'm just going to cut in here. All right. We'd like to, a quick reminder again about the special multi-course promo we're offering to prospects now through the end of May. We're taking 10% off any multi-course package. Our multi-course packages are already deeply discounted, and this is an opportunity to make it even sweeter to get your compliance training program on track now. So if you'd like to have someone contact you right away to talk about our special promotion or to see a product tour of any of these courses we've discussed today, please click the radio button here for 30-minute training consultation. If you're not interested in being contacted about training, please do not click this button. I repeat, don't click the button unless you want us to call you for a 30-minute training strategy discussion. Click the other buttons or just don't click anything and we'll progress the slides forward shortly.
Liz, do we have some good questions to answer?
We do. We have some great questions coming up here in a second. Actually, we have quite a few. Let's just get these poll results in here. One you could just go ahead and start on right now if you want is, do these three areas, these core compliance areas, these three areas need training annually?
Yes, and I'll give you the reasons for that. There are numerous cases which your Workplace Answers representative can discuss with you that show that annual training is required. And the EEOC guidelines talk about that. And training needs to happen every year because the law is changing in every one of these ways. In harassment, it's changing constantly. In discrimination, in wage and hour. Your employees and supervisors need to be up to date. And again, this goes towards your affirmative defense. If you give them an old course that doesn't reflect the new law, that is not going to reflect well on you as an employer.
Okay, great. Then we also just have a quick question about whether temporary employees need to be trained.
Yes, yes, yes. And that is a huge oversight that many employers make. A temporary employee is your employee. Even if they work for you for 2 months, you have potentially more liability with temporary employees because temporary employees might not be in the workforce all the time. They don't know the new legal standards. They might be people that are re-entering the workforce after a time. They might be students who have never had a job before. So your liability is exactly the same with temporary employees as permanent employees, or not permanent but regular employees.
Okay, great. And then somebody was just asking if they aren't doing in-person training, what would you recommend to stay in compliance?
I think web-based is the wave of the future. I think it's what juries want to see. Juries have a lot of young people on them, and young people are very technology savvy. I think they view in-person training as an outmoded way of doing things. I think there are, as I said, very dangerous downsides to in-person training. And I have seen many employers actually get sued over their in-person training because it's either done in-house by HR people who don't have the appropriate legal knowledge. I think having an outside expert, an outside vendor like Workplace Answers, a web-based vendor, shows that you have really gone above and beyond your duty to provide the best training on the market. And I think that avoids punitive damages.
And then just on top of that, how do we prove they actually stayed for the training?
Well, that is part of Workplace Answers Learning Management System, the SLATE management training. It shows that the employee, the amount of time they spent in the course. And they can't just click through like you can do with some DMV courses. They actually have to read the questions, and they have to review their employer's policy as part of the course. They can't just click and say, I've completed the training, I'm done with it. They actually need to interact completely all the way through the course. And you can't prove that someone stayed in in-person training. I've had that case many times where the person said, well, I didn't get the training. I was called out on an emergency. So I didn't stay for the training. I only stayed for the first 5 minutes. How do you disprove that as an employer? It's impossible.
Yeah, that's very interesting. And we also have, we're going to close out the poll right now. So if anybody wants to get their answers in, just really quickly, it's your last chance right now before we just move on from that. Okay, and the next question was kind of a follow-up to the temporary employees, and it's, do contractors need to be trained as well?
Yes, they do. Contractors are third parties. They deal with your employees. They can harass and be harassed by your employees. So, and also, if you hire contractors through an agency, don't count on that agency training them. Agencies do not do training that's comprehensive or anything you'd like to rely on. And they, if there is harassment or discrimination or a wage and hour violation, they are going to sue you probably as well as the agency. So who has the deeper pocket? You probably do.
Okay. And we have about just enough time for 2 more questions. So one of them is, do you recommend that HR conducts a follow-up discussion following online web-based training to verify that the employees understood and confirm that they actually completed the online training?
Yes, I think that's an excellent idea, and I believe training needs to be an ongoing event, not a one-time event. This is something that supervisors should be discussing in their meetings. There are group meetings with employees. They should be discussing it one-on-one if the employee has any questions, if they have any problems with third parties. And I recommend like brown bag lunches or an open discussion, and making sure that employees really did get the core meaning. And I've been very surprised. I've gone in and done in-person training after employees have taken web-based training. Employees take web-based training much more seriously. They remembered, oh, Liz was the one wearing that sexy dress, or the multiple choice answers to that question were so-and-so, and I've been amazed at what they retain. Because frankly, in in-person training, a lot of employees roll their eyes and say, here's the HR person again, here's the attorney again, and they make a joke out of it. But you take it much more seriously if you do it one-on-one with you and the computer.
Great, and this is the final question. It's kind of going the other direction from training contractors and temporary hires, is do board members and other volunteers need training as well, and is that the same for nonprofit organizations?
Absolutely yes. Again, there's third parties who interact with your employees. They can sue you for discrimination or harassment. Your employees can harass them, and they can harass your employees. So yes, most definitely. And I really think the board members, the board of regents, all the board of directors, those people perhaps need it the most, because they are setting the tone for the entire organization, and this is a top-down effort. How would you defend a case if you said, well, we did some training, but we didn't train our board of directors? That's a critical mistake, and a jury is not going to look favorably upon that. I mean, how hard is it to train maybe 12 people on your board of directors? Not hard.
Yeah. Well, thank you so much for joining us today, and thank you, Lynn, for a wonderful presentation. We're going to have to cut it off there for time. But if everyone would please visit workplaceanswers.com for more information on preventing harassment and discrimination in the workplace. You can also learn more about our wage and hour training, which is a huge element of the training. The training that we provide is up to date and is very dynamic. It involves storylines, questions, little quizzes. So it's great online training. And also, as a reminder, you will receive an email with a link to view this recording of this webinar, and you'll also get a link to a downloadable document which will have our key takeaways from this presentation. So thank you for following along with us, and if you'd like to continue the discussion, please hop on Twitter with the hashtag #HRCompliance. Thanks for joining us.
Ladies and gentlemen, that does conclude the presentation for today. We thank you for your participation and ask that you please disconnect your lines.